agenge en agenge agoi kapkirwok noton nebo Milimani. Olitan kotinyege ak kesit nebo istoet noton ko Rigathi Gachagua en boroindo noton nebo rubeiwot nebo president. Kikimuch keisto Rigathi Gachagua en tarikit noton 8 en noton ana en kenyit noton nekosirtoi. Ole agot kou noton kokimuch ko kapkirwok Rigathi Gachagua agoesio istoenyin ana kimuch kokoito kang'unyet en mwoe kole makimuch kisib tetutik choton chebo katiba. Kimuch koisto ine bunge noton nebo boror kotinygei ak lelutik choton chekimuch kemwaita en inendet kasita noton nekinemu boroindo noton nebo rubeiwotab president. Akot kou noton kesit noton kondochin kirwogik somoku noton ko Eric Ogolla, Freda Mogambi ak Anthony Mirima. Amache amutin agenge en agenge agoi kapkirwok noton nebo Milimani asikekat kit noton netesetai en inguni.
Threshold in all material respect. With regards to the Senate not conducting its own public participation, the petitioners contended that the Senate acted in violation of Article 118 of the Constitution by failing to conduct its own independent public participation exercise prior to deliberating on the impeachment of His Excellency Gachagua. This argument, while not without surface appeal, cannot be sustained upon a careful and purposeful reading of the constitutional architecture governing impeachment proceedings, and we reject it for the following reasons. The starting point is the principle of constitutional specificity. Where the Constitution makes express and particular provision for a specific process, that specific provision governs, and general provisions must yield to it to the extent of any inconsistency or tension. Article 145 of the Constitution prescribes with particularity the role and function of each House of Parliament in the impeachment process. Under that provision, the Senate's designated function is to hear the charges preferred against the Deputy President, to receive and evaluate evidence in respect of those charges, and to decide on whether the Deputy President should cease to hold office. This is, by its very nature, an adjudicative function, and one that is quasi-judicial in character, akin to the conduct of a tribunal. It is not a legislative or policy-making function. The Senate, at this stage of the process, sits not as a law-making body, but as a constitutional adjudicator, and the procedural obligations that attend to that role are correspondingly different. Article 118, by contrast, imposes obligations on Parliament in the conduct of its legislative and other business. It provides in material part that Parliament shall conduct its business in an open manner, that its sittings and those of its committees shall be open to the public, and that Parliament shall facilitate public participation and involvement in its legislative and other business. The operative phrase is legislative and other business, and the interpretive question is whether Senate's adjudicative role in impeachment proceedings falls within the scope of that phrase. We find that it does not. The phrase other business must, on a proper application of the Eusdom Generis canon of construction, be read as business of a similar nature to legislative business, that is, business involving the formulation, review, or consideration of policy or law. We respectively associate ourselves with and adopt as correct the position taken by this court in Mwangaza versus County Assembly of Meru, that public participation in impeachment proceedings primarily occurs at the county assembly level rather than at the Senate level, since the county assembly is the initiating body that formulates and debates the impeachment motion before transmitting it to the Senate for final determination. End of the quote. At the Senate stage, the function being discharged, as we have said, is adjudicative rather than consultative. We find that the constitutional principle underlying that holding is not confined to the impeachment of governors. It is a principle of general application that derives its force from the structural logic of the impeachment framework embedded in the Constitution, and it applies with equal force and validity to the impeachment of the Deputy President.
Ko agenge gubun kap kiruang not na ba milimani na mi count na ba Nairobi o litisatay gaset na ba gesit na tinye kaya agistoit not na ba Rigathi Gachagua in baroinda not na ba ruwayo na ba presidenta. Gestoy galagoy chotan baro kap